Hi, our conference starts today with the topic of bail, homelessness, addiction, and mental health. Topic close to all of our hearts, I'm sure. Wait a second. Her Worship Karen Valentine, Justice of the Peace from Ontario Courts of Justice, will speak. Justice Valentine was appointed in March 2014. She presides over the Toronto region, where she interacts regularly with vulnerable individuals in busy criminal, bail, and case management courts. She brings an equity and inclusion lens to her various roles in the outside of the courtroom. She obtained a Bachelor of Laws from the University of Windsor in 2001 and was called to the Ontario Bar in 2002. She also has a Master of Laws with a specialization in criminal law and procedure from Osgoode Hall Law School. She is an AGA PEO criminal law and procedure, representative from the Advisory Committee on Education for the Justice of the Peace bench, and often mentors and assists with the training of her colleagues and other legal professionals. She has lectured at annual conferences of Justices of the Peace, the Ontario Bar Association, and the Criminal Lawyers Association on bail, case management, and cultural competence topics. Before her appointment, in addition to other roles in the community, she was the first elected African Canadian person to chair a school board in the Durham region, Ontario. I believe that we have Aspasia Papatheodorou, Duty Counsel from Legal Aid Ontario also. Thank you.
Yes. Thank you, and good morning, everyone, and thanks for inviting us to talk to you all about the substantive and practical issues that we often encounter in our busy bail courts, especially when we have vulnerable individuals seeking bail who may have mental illness, substance abuse and addictions, and who also face housing insecurity and homelessness. Aspasia and I are going to walk you through some of the issues that we frequently encounter in our courts by taking you through a scenario. And the scenario is as follows. Michael Tremblay was recently arrested and charged with theft under, assault, and failed to comply with a release order. It is alleged that he stole a bottle of alcohol from a liquor store and struck a loss prevention officer as he fled. He was already on a release for an arrest that occurred about 7 months ago for stealing alcohol from a different liquor store. A condition of that previous release order is that he not attend that particular liquor store. He is 26 years old, unemployed, and has no fixed address. He is originally from a small town in Nova Scotia where most of his family remain. He has a lengthy criminal record, is addicted to crack cocaine and alcohol, and may have an undiagnosed mental illness. The Crown is objecting to his release because they are insisting that he have a surety. Aspasia, can you please walk us through some of the substantive and practical issues that you might encounter when preparing for Mr. Tremblay's bail hearing?
Yes, of course. Good morning, everyone. So I'm just briefly going to say, for context, the situation that we are dealing with, our practice situation here, we're dealing with the current situation that we have now in the courts and the changes and constraints that the pandemic has brought to our court system. So things like all clients are going to appear by video from the division, so we don't get to see them in person once they're arrested. And I should also say that I'm going to be speaking from a Toronto perspective, because that is where I practice and that is where I've always practiced. That's also where Her Worship practices. And a lot of the constraints that we will be discussing are certainly things that other jurisdictions are dealing with and may have been dealing with for much longer than us. I know in Toronto, prior to the pandemic, lots of clients were coming in person upon arrest, and we get to see them. And that's not a situation that's always the case for outside communities outside of large cities. So in saying all of that, I will start from the moment of arrest. So we have Mr. Tremblay, he's been arrested. And I do know that he's dealing with some substance use issues. And so it's very often when you have clients who are dealing with both mental health and substance use disorder to get instructions on that first day of arrest. The client may be coming before you after arrest not feeling the best. They may be dealing with symptoms of withdrawal. For clients who are dealing with mental health issues, if they may be dealing with active psychosis, depending on what drugs they're using, that could be exacerbated. So you have a situation where you have a client who is maybe not feeling well, and it's quite hard for them to provide instructions to you. It's further complicated by the fact that I don't get to see them in person. I'm not at the courthouse, they're not at the courthouse, where I can tell the officers, can you just go to the cell and tell them they need to come talk to me? At the police division, it's extremely busy. Their resources are more stretched. There have been days recently where their video systems are not working. There are fewer rooms to interview clients. So if you have a large number of people who've been arrested and very limited space, let's say 2 rooms that they can be interviewed, and someone is not feeling well and tells the officer, I'm not coming, there is a chance you're not going to speak to that person that day. That is very problematic because in this case, Mr. Tremblay has a new charge. Yes, there is an assault, resist arrest, and I would never minimize that sort of thing, but it is, the charge is stealing another bottle for someone who has an addiction issue. And because of the way the system is set up, I may not get instructions from them, and that person may stay in custody for longer. That then creates other issues. Unfortunately, our access to clients at the jail has been limited a fair bit because of the pandemic. There are various ways that we can access clients. There are defense calls or video meetings that we can set up. However, those often get canceled. They often get rescheduled. Sometimes they'll be scheduled for 4 p.m. in the afternoon, and you want the client to be back in bail court the next day. If you have an appointment with someone at 4 p.m. the next day, they're staying in custody for another day. So access to the clients has become a serious issue. And when a client is dealing with other issues as well, they're dealing with substance use disorder and they're dealing with mental health issues, they may not be able to advocate for themselves as much in the institution. There are duty counsel who are in the institution, but if you are in withdrawal and not feeling well or in a mental health crisis, your first thought is not going to be to ask to speak to a duty counsel at the jail. So the access to the clients then creates another barrier that is disproportionately it disproportionately negatively affects clients who are dealing with mental health and substance use disorder issues. The other issue is then it becomes very, very hard if part of our bail plan is to refer them to social workers and the social worker wants to speak to the client before. If they are now at the jail, it becomes very hard for the social workers to get access to them. It's hard enough for the defense lawyers too. The situation is compounded for social workers. In some cases, at some of our jails, we do have CAMH within the jail, so we can get access that way. But for the most part, it is very tough then to get access to the clients. Once I am able to speak to Mr. Tremblay, my next step is to get an idea of what his challenges are. So I do understand he's dealing with substance use disorder. He is dealing with homelessness, and there's possibly some mental health there. There may also be an acquired brain injury. So my job at that point is to find out from him, does he have community workers? Does he have a probation officer, any drop-ins or clinics or doctors that he sees, and getting permission to speak to those people, because he may not be in a position where he can recount his history to me because he's not doing well. But if he gives me permission to speak to those workers, then maybe I can get some of that information and then create a bail plan so that we can try to get him out of jail. If he doesn't have any of those supports in place, I then will speak to him about whether or not he's willing to work with community or court supports, and then refer him to the appropriate agencies. I'm sure anybody who works in this field will know that access to those resources was tough before the pandemic, but it's become really, really hard since. Shelter beds, there are fewer in the city. This is a man dealing with homelessness. It's going to be harder to get him a shelter bed. Shelters have lower capacity numbers now so that they can try to distance people. The hotel programs are being closed down. So there are less beds for clients who are dealing with homelessness. Detox beds have also shrunk. Especially for women in the city. We had one organization that had detox beds specifically for women, and they closed during the pandemic for renovations and haven't reopened. A couple of hospitals in the city do have detox beds, but if you're a woman who needs a detox bed in Toronto, it's really, really hard to get you one. So you have these resources that are basically stretched to the brink. You have mental health organizations in the city that are seeing much higher requests for their services, that are trying to assist everywhere they can, but they just don't have the resources to assist. So in this case, I will try to put together whatever plan I can. If he has his own workers, try to get those support letters. If he doesn't, make those referrals so that he can speak to the workers at the courthouse. Sometimes it does require to bring him into the courthouse so that he can speak with them and have access to those workers to get a plan together. Once that is done, and unfortunately that may take a few days. So again, the disproportionate impact for someone who is homeless and doesn't have any family who can sign a bail is that they may stay in custody longer before we deal with their bail. Once I have the plan together, I will at that point obviously speak with the Crown and try to negotiate a consent. We may need to run a bail hearing, but I will speak to them about some of the issues, and a lot of the Crowns will know some of the issues that we're dealing with, but discuss if he has an ABI, if he has community supports, what he's struggling with, various things. So the Crown in that case may actually consent to the release depending on the plan, specifically with respect to whatever context I can provide them and information I can provide them about my client. In some cases, this is something that we may raise during the bail. I know that Her Worship and other justices of the peace and judges don't often know about some of the things that are going on within the community and some of the constraints that we have. And sometimes, we will create a consent, for example, that has some creative conditions that may not on their face, it may not be obvious why we're asking for those things. So that's the kind of information that we might provide to the court to say, yes, we are having him not attend this specific address, but then there are other conditions, or whatever condition we may come up with, we may provide that context just so that Her Worship understands why we are proposing that, because there are a lot of things going on, and she may not be aware, for example, that we were told there are no detox beds, or the wait time at this mental health organization is 8 weeks, and that's why it can't be immediately put on the bail. But we've put that should the court or the Crown ask for proof, the client needs to provide it in the next few court appearances or something like that on the bail. So I'm going to turn it over to Her Worship so she can talk about the more legal side of what we're dealing with when we're dealing with a client like Mr. Tremblay.
Thank you. And in this particular scenario where the Crown is objecting to his release, specifically because he does not have a surety or someone to supervise him in the community, one of the first things that I want to canvass with the Crown directly is I'd be curious to know whether the Crown would have consented to Mr. Tremblay's release if he did propose a plan that included a surety. And I would ask the Crown this directly, just so that we may not necessarily have to go into a long hearing, and just to kind of bifurcate or hone in on a focus hearing with respect to the form of release, particularly if I can elicit from the Crown that their only objection is not necessarily that Mr. Tremblay should be released or can be released in the community to await his trial, but that they would want a surety or a more restrictive or onerous form of release. And I appreciate that there are significant differences in the way that bail is adjudicated across the country. Ontario appears to be the only jurisdiction to primarily use justices of the peace to preside over bail hearings. And I think the Yukon uses a combination of justices of the peace and judges, and Manitoba, Nova Scotia, British Columbia only use judges in bail court. But the reason why I mention that is just because there's variations throughout the country. And where I preside in Toronto, where we have one of the busiest provincial court jurisdictions, we were extremely busy before the pandemic, as Aspasia had mentioned. But it's not uncommon now, post-pandemic in a virtual world, where we are seeing up to 50 individuals in our bail courts on a daily basis. And in Ontario, where our Justice of the Peace bench is a lay bench, although it includes lawyers, paralegals, former police officers, social workers, and other non-legally trained individuals or professionals, there are a number of issues collectively that we put our minds to. And so I just want to put that out there, just because I know that in different regions, non-legally trained persons, as well as judges, are also doing bail. So for some reason, I will also note that police releases are becoming less frequent, and many individuals are being held for bail, even though police do have the discretion to release someone with or without conditions from the division. And so that also kind of compounds or exacerbates the issues that we're seeing, because oftentimes those people who are held for a bail hearing do come from some of these vulnerable or have these vulnerabilities, as opposed to someone who may have someone to supervise them in the community, et cetera. And so when a person is held for bail or interim release, the general rule is that he or she should be granted a release pending their trial, unless the Crown can show cause as to why they should be detained. And an accused can only be justifiably detained on 3 reasons or 3 grounds. One is to ensure that they attend court. The other is to protect the public and to prevent the commission of a further criminal offense, as well as to maintain public confidence in the administration of justice. And I know some of you are lawyers, and so this might not sound new to you. However, my understanding is that there will be all kinds of individuals watching our presentation. And so requiring the Crown to show cause for detaining an accused person is consistent not only with the presumption of innocence, but also with the accused person's right to a reasonable bail under the Charter. And the right to a reasonable bail is also reinforced by the principle of restraint. And the principle of restraint has been recently, in the last couple of years, added to the Criminal Code, sections 493.1 and 493.2. That is that decision makers under Part 16 of the Criminal Code, police officers, justices, or judges, must give primary consideration to the release of the accused person at the earliest reasonable opportunity and on the least onerous conditions that are appropriate in the circumstances, including conditions that are reasonably practicable for the accused to comply with, while taking into account those grounds. Many of the accused persons who appear before me in bail court often have precarious housing, mental illness, or addictions. They become what I refer to as our frequent flyers or turnstile clients, because in addition to substantive charges, they may have accumulated several administration of justice offenses, such as failures to comply with court orders, while they're waiting to deal with their earlier substantive charges. These breaches now shift the onus to show cause why the individual should be detained from the Crown to the accused now having to show or demonstrate why they should be released, as is the case of Mr. Tremblay. Unfortunately, individuals like Mr. Tremblay are more likely to find themselves spending more time in pretrial custody awaiting the conclusion of their case than if they were to receive a custodial sentence. And I often take this into consideration, especially when I'm considering a criminal record, albeit a lengthy criminal record, that includes dispositions with minimal to no custodial sentences. An accused person who's a member of a vulnerable population will often be unable to present, as Aspasia has mentioned, to present a conventional release plan that will include a surety. And so we are mindful then when we are presiding in these courts that the Supreme Court of Canada has acknowledged that courts have been relying very heavily on sureties as part of a release plan, which can not only be onerous as a requirement, but it may not even be necessary. And oftentimes when dealing with accused persons with mental illness, addiction, substance abuses, and precarious or no housing, I'm tasked to consider the merits of an unconventional release plan. In the case of Mr. Tremblay, he has no family in Ontario, does not appear to have anyone who can supervise him in the community. He's unemployed. he may have few meaningful relationships with other persons, or his relationship with the community support agencies may not be fully established. So when I consider these types of cases, I try to be mindful of these challenges and limitations that vulnerable accused persons live with. If I'm being asked to consider a community agency that I'm unfamiliar with as part of the plan, I will ask about the availability and quality of the support that the agency is able to provide, because the existence of supportive relationships can contribute substantially to mitigate the risk of post-release offending behavior. The more information about the available supports and the benefits that the support provider may have, when we have that information, it gives us a better position to be able to evaluate the merits of the release plan and to ensure that any interim release order that is made takes into account the particular circumstances of the accused, as well as the challenges that he or she might face. Ultimately, I think that each interim release hearing involves consideration of a community organization, such as bail program or community mental health, for example, gives us as judicial officers an opportunity to better understand the local environment and available resources. And again, as Aspasia has pointed out, the lack thereof post-pandemic. And one of the challenges that I often see is that persons like Mr. Tremblay, who may be in and out of the system, finds that sometimes they become ineligible or disqualified from participation in these programs by virtue of their alleged breaches. This means that I may be asked to sometimes release an individual on a bail that is less onerous than the previous release that they were once on. And I will say that I appreciate the limitations that duty counsel and private counsel faces under the current regime when it comes to bail. However, I would still encourage counsel to provide very detailed information, if they have that information, about the operations and resources of community organizations that are expected to support vulnerable accused clients if he or she is ordered to be released from custody. But it also gives us an opportunity to learn about the resources that are available within the community that we may not be aware of. So this is a perfect segue for me to talk about section 493.2 of the Criminal Code, because as part of the principle of restraint that we must consider when deciding whether or not to grant a release, the court must also give particular attention to the circumstances of A, Indigenous accused persons, and B, accused persons who belong to a vulnerable population that is overrepresented in the criminal justice system and that is disadvantaged in obtaining release under Part 16 of the Criminal Code. This remedial provision has been added to the Criminal Code a few years ago now with the passing of the Omnibus Bill C-75. Police officers, justices, and judges must put their mind to the systemic issues of the overrepresentation of these vulnerable populations in the criminal justice system generally, and in the remand population specifically. There is often overlap and intersectionality of more than one particular vulnerability. For example, a person can be Indigenous or Black and also have mental illness and have unstable housing. They would be captured by section 493.2 because of the disproportionate representation they comprise in the criminal justice system. The second part of this criteria is that these particular vulnerable groups have been disadvantaged in obtaining an interim release, maybe for the reasons I've stated previously and the reasons that Aspasia has stated, and maybe for other reasons. So a judicial officer, myself included, when I'm deciding whether to grant interim release, I must be live to the issues of overrepresentation. And I ask myself regularly whether or not the decision to deny someone bail is perpetuating the systemic problem of the overrepresentation of this particular group. Similar to how we treat youth contested bail hearings, I think we must always consider whether any reasonably practicable conditions or combinations thereof can mitigate the risk based on the statutory just cause grounds for detention. In the case of Mr. Tremblay, I'm reminded of Regina and Morales, which is a Supreme Court of Canada decision, which states that bail is not denied for all individuals who pose a risk of committing an offense or interfering with the administration of justice. Bail is denied only for those who pose a substantial likelihood of committing an offense or interfering with the administration of justice, and only where that substantial likelihood endangers the protection or safety of the public. Moreover, detention is justified only when it is necessary for public safety. So similar to section 28.1 of the Youth Criminal Justice Act, I take the approach that a vulnerable person should not be detained in custody or be released on conditions for social welfare purposes. If all of the circumstances, including the proposed plan of release, leads me to find that Mr. Tremblay has not shown cause why he should be released due to his membership in a vulnerable population disadvantaged in obtaining a release, I next ask myself in my decision to detain Mr. Tremblay, if my decision to detain Mr. Tremblay is based on some sort of bias, known or unknown to me, that I might have against the vulnerable group that he is a member of, or even the nature of the charges before me, or maybe because of how he presented or behaved in court, all of which may be impacted by his illness or other vulnerabilities. What if Mr. Tremblay was particularly abusive in court or difficult to manage? This section of the code necessitates a lot of self-reflection by judicial officers in this regard. I would encourage judicial officers to look at some of the anti-bias bench cards or checklists that can assist with the types of questions to ask yourself when deciding whether or not to grant an interim release under Part 16 of the code. Also, as a decision maker under Part 16 of the code, I may not know about an accused person's vulnerabilities if it is not obvious or disclosed to me at the hearing. I have now incorporated as part of my practice in court to ask at the start of a hearing whether Section 493.2 applies and how it applies. This usually alerts counsel to submit evidence or information so that I can make a proper assessment under this section. I am mindful that when inquiring about the personal circumstances of an accused, that I elicit only the information that is necessary to meaningfully evaluate the proposed release plan. My advice is that the limits to this inquiry about the personal circumstances of an accused, as identified by counsel or even the accused person themselves, should be respected, because discussing private life in a public forum can be stigmatizing and also traumatizing. So the takeaway from my discussion is that making decisions about the interim release for accused persons with mental illness and addictions, in addition to poverty and isolation, can be very challenging, and so can crafting realistic release orders. So I'm going to just mention the case of Zora, which is a leading authority. It's Regina and Zora. And we're required to consider, when making determinations with respect to interim release of vulnerable persons, whether or not the plan addresses some of these issues. So the court has observed that when we prosecute a number of individuals for failing to comply with conditions of an undertaking or release order as it relates to vulnerable persons, it often involves questionable release conditions that are imposed upon them. So the court states that the principle of restraint requires that any condition of bail be clearly articulated, minimal in number, necessary, reasonable, and the least onerous in the circumstances, and sufficiently linked to the accused risk regarding the statutory grounds for detention. The principle requires everyone, especially judicial officers, to scrutinize bail conditions at the release stage, whether bail is contested or on consent. Release conditions should be tailored to the unique circumstances of the accused in order to address those risks, and they are supposed to be imposed with restraint, not only because they result in the limitations of liberty of persons presumed to be innocent, but also because they often criminalize what would otherwise be considered to be lawful behavior. A couple of those conditions, and Aspasia, I'm sure you've made lots of submissions with respect to these conditions. One, conditions that directly address symptoms of addiction. So for example, alcohol or drug abstinence conditions, which we no longer impose, but the odd time we may be asked to do so. But it's most Crowns don't even make those submissions to me because they know where I stand with respect to those conditions. Conditions that are designed to encourage rehabilitative behavior, for instance, counseling and or treatment conditions, are only appropriate if they are sufficiently related to the accused risks. But again, we use those very sparingly, and I should say I use them very sparingly. The condition to keep the peace and be of good behavior is not a required bail condition, so I never impose that condition. And conditions that delegate the discretion of sureties or others to establish bail rules effectively bypass judicial scrutiny, and they should be avoided. And so those are conditions such as follow the routine and discipline of the address. Unfortunately, I've seen sureties pull bails because an accused person on a release order did not throw out the garbage, and that was a condition that they imposed separate and apart from the bail conditions enumerated in the release order. And so I'm mindful of those particular issues, and especially as they are conflated with respect to vulnerable persons. And I do see Aspasia nodding because I'm sure that she encounters that often in our bail courts. So one of the things that I will say with respect now, turning to the situation of Mr. Tremblay that we've discussed, is that in this scenario, because he's facing additional new charges of theft under, fail to comply with a release order, and assault, if the Crown's only concern is that his release plan includes supervision by a surety and he does not have one, if I'm satisfied that an unconventional release plan sufficiently mitigates against the risk to reoffend and public safety, I would grant his release without a surety. So I'm going to now just turn to Aspasia because we've been having really good discussions since we started preparing for our presentation. And one of the questions one of the discussions that we had involved Aspasia telling me, about her appearance in drug treatment court in Gladue Court. And I wanted to know specifically if you can share with us what that's like if you're appearing on bail matters, or have you noticed any differences in how bail is treated in a therapeutic court versus a regular bail court?
Yeah, certainly. So there is a difference. With respect to drug treatment courts, our drug treatment court does require a guilty plea to take charges in. In that case, there's usually a guilty plea, but then there's a bail to deal with afterward. The mental health court clients often are coming back from treatment orders, and we will deal with a bail if the client is fit. In many cases, not all, there are some cases where that's not going to work out because of the seriousness of the charges. But let's say it was someone like Mr. Tremblay coming back into the mental health court, then certainly that's a bail that we would try to negotiate and deal with in the mental health court. And in Gladue, we do run contested bail hearings, but it is a different situation. And the greatest benefit with respect to the specialty courts and to therapeutic courts is that everybody involved there on that team has specialized training and is familiar with the issues that we're dealing with. So we have, for example, in our mental health court, we have a concurrent disorders worker. We also do have social workers that are attached to the court, who are fully aware and more aware than we are of what it's like on the ground and what resources are currently available and what's not available. You also have crowns and judges and justices, well, it's judges in these courts, but crowns and judges who know the same things and they've dealt with these issues. And in the case, for example, of drug treatment court, the judge has a lot of information about the client. So if, for example, the client we knew had an acquired brain injury, we're going to be very careful about the conditions that we put on that release and how we explain them to the client. And we're going to strive to create a bail that is something that is not setting the client up to fail, taking into account the very specific issues that they are dealing with. There's also additional resources in those courts, resources that are underfunded, as I'm sure everybody here will know, but we do have our treatment partner for our drug treatment court is CAMH, which does have a lot of resources, which is very helpful. We partner with Aboriginal Legal Services and our Indigenous Persons Courts. And our mental health courts, there are various agencies that assist, but at Old City Hall, it's Fred Victor, an agency there. And so you have all of these workers. We have caseworkers and court workers who will attend from Aboriginal Legal Services to our Indigenous Persons Court, but they also have an organization behind them that has other workers. They have FASD workers, they have other workers that they can, and resources that they can refer clients to and come up with a plan that, while it may not have, you know, that surety supervision that the Crown and Mr. Tremblay's case is looking for, does have increased support in the community and resources that specifically would assist a client like Mr. Tremblay. In drug treatment court, all of the clients have their own therapist, and they have the other resources that we have a probation officer who works with us. So if the client is on probation, they can also assist. It's that specialized knowledge. There are specific psychiatrists who come and work with our mental health court who could assess clients for a diversion. For a matter like this is certainly something that we would speak to the Crown about, maybe getting this toward that path. And if the Crown is saying, yeah, this is something that's divertible, then why wouldn't they agree to a bail? So that's the sort of thing that is the difference with those specialty courts, is everybody gets it, everybody knows what's going on, and everybody the justice system is an adversarial system, but the great benefit and what I really appreciate about working in the therapeutic courts is that everybody is working as a team, and everybody understands what a blunt instrument the justice system is for people who are dealing with substance use and mental health issues.
Thank you. And I think we may have some questions. I'm going to turn it over to Keisha, perhaps.
Oh, looks like we do.
Yeah. You're muted. I know that there we go.
I just came up. Thank you. Thank you, Justice Valentine. So I just have one question in the chat, and it's from user Melva. In thinking of the scenario presented for Mr. Tremblay, what is the relationship like between duty counsel and the treatment and programs department in correctional facilities? I've also typed in, oh, sorry.
Sorry, go ahead.
I was just gonna let Justice Valentine know I put it in the chat as well.
Oh, okay.
In case it was read too quickly.
That's fine, thank you.
So with respect to that question, we don't deal much, at least as a duty counsel who works in the courthouse, we don't deal much with treatment and programs at correctional. I know that we do have institutional duty counsel, at least in Toronto. So there are duty counsel there for the big jail, the Toronto South Detention Center. There are 2 duty counsel who are permanently assigned there, and then other duty counsel who assist. With respect to some of the changes the pandemic has brought, for a very long time, over 2 years, we did not have duty counsel in the jail. They would just receive calls in the morning from the clients. And so when you're not actually physically there, you then start playing phone tag. So I know that those duty counsel who are within the institution, there's, like I said, 2 of them, and there's 1 on any given day now because of the pandemic. I know that they do have relationships with some of the staff at the jails, the social workers, the various people who are on site. So I know that sometimes they do help us facilitate things. But for the most part, as a duty counsel at the courthouse, it's impossible to get a hold of anybody who might be able to assist. Like I said, we do have ChemH there at the jail, and that has been very helpful. That started before the pandemic, but certainly within the pandemic, sometimes that was the only social worker I could ever get a hold of at the facility. With respect to the jail for women, it's the Vanier institution here for us in Toronto. I've had slightly more luck getting a hold of a social worker, but still it's a lot of phone tag or email tag. And if you're trying to ensure that someone who you think might be in crisis needs to be seen and they're not being seen, it's really hard to play email tag or phone tag for days when you know someone is suffering and doesn't need to be. So it's been tough, and it's gotten worse because of the pandemic. So us getting access to clients at the jail and getting access to workers who might be at the jail.
So can I just add to that? Because one of the things that I've been doing is requesting that individuals be brought into the courthouse on their next appearance so that they can have an opportunity to see duty counsel. I know now that everyone is returning back to in-person appearances. That includes all of the crowns and duty counsel, whether it's on a rotation basis or on a full-time basis. But by bringing individuals into the courthouse, I think it's an attempt to try to alleviate some of those concerns so that they can see, for example, a mental health worker or even duty counsel. I can tell you that in bail hearings, they're now conducted similar to this fashion by Zoom, where sometimes a division or a jail or an institution does not have access to a video camera. And so they're putting individuals on the telephone who are only hearing voices. They can't discern who the Crown is, who duty counsel or private counsel is, and even who the justice presiding is. And so although we're identifying themselves, you can only imagine when someone's in crisis, how that might appear to be for them, and who's speaking and who to trust, et cetera. And so there are a lot of issues that I notice when I'm presiding in a bail court, and I'm always astute to those issues. And so even on the most busiest days, I try to make allowances to have, for example, an accused person speak to counsel in a breakout room, for example. Obviously there's limitations as to how much time I can give, but these are a lot of the issues that we're trying to address with respect to, access, and so that, good bail plans can be put together. And we're aware, and I don't want to speak for everybody else, but I do think that the bench is astute to and live to those issues as well, right?
Yeah, and that's certainly something that that we have been doing more, is asking for clients to come in person. I think, especially for a client you might think is in crisis, it is important to actually see the client and for them to see you. The first almost year of the pandemic, everything was done by the phone.
Yeah.
I don't know why you would trust that, especially if you're someone who is accustomed to the way the justice system works and you're in crisis and suddenly it's just voices and you're being told it's because of the pandemic. I don't know. I mean, I might think that they were lying to me too. So it's one of those things that has been a serious problem. And yes, we will ask if it's become a serious issue, and a couple of days have gone by, then we'll ask for the client to be brought in person. And I know they don't like it, and I don't really care.
Yeah. And I know that we're almost done, but there is something that I do want to add, because with the inclusion of section 493.2 in the criminal code, when we talk about vulnerabilities and just putting our minds to that before we decide to detain somebody who is captured by this particular section, I often hear submissions, and I don't mean to pick on the Crown because we don't have a Crown on our panel, but I often hear submissions by the Crown that, well, this person has upteen amount of releases, therefore, they haven't, they're not prejudiced in the way of securing a release order, so section 493.2 doesn't apply. Well, that doesn't abrogate their membership in that particular group. And so we often hear that. And so when we're dealing with vulnerable persons, we have to think about the impact of our decisions, whether or not to release or to detain, and the impact that it has systemically overall on the criminal justice system. So yes, with respect to bail and dealing with particular individuals with vulnerabilities around housing insecurity and mental illness and addiction, there's a larger systemic problem that we always have to keep a finger on the pulse to. And that's the hope that, and I do see that we're moving in that direction with respect to always being live to those particular issues and how it does impact the system. So
I'm sorry, Your Worship, I could ask us a question. I work with the homeless population, people experiencing homelessness in St. Thomas, and for 5 years, and we've came up with kind of the same ideas you guys have come up with in the courts for housing, is that it needs to be a non-traditional approach, something different. You use the words unconventional release if somebody didn't have a surety, if they're a member of this vulnerable group, qualified for the special needs of your that unconventional release. We call it non-traditional housing that we're asking for. It seems that the thinking is the same, and it's beautiful to see. And I really thank you for doing it. If you just knew how important it was to continue that view of how critical these people are and how much they need the system's help, and how you guys are the answer. And sometimes we're also the problem along the way, but that's what this is about. Courage to improve today conference, and you've certainly showed us some wonderful examples of that.
thank you. And in all fairness, with the scenario that we raised, one of the reasons why we raised that particular scenario is because we often encounter the request to impose a surety on someone where it's not necessary to address the concerns, right? And so, and not just requiring a surety, but requiring a residential surety, and that's, you know, compounds the problem even more. And so, I appreciate, you know, that different areas are doing different things, and these are opportunities for us to all learn from each other. So thank you so much for your comments, Dan.
It's funny you say that. Twice in the last year, I was asked by a local lawyer if I could be a surety, and I couldn't do residential surety with my friends. It just wouldn't work, but I could do non-residential and stuff, but that they're not ready for that yet around St. Thomas, but soon we hope, you know, the growing concern and realization of these people's actual lot in life and severity of their criticalness. It's coming to light, and just thank you so much.
Thank you.
And I think that's why it's very important, and I also think that's why things in the specialty courts tend to work better, because everybody does know about those things, and everybody understands the context and the situation that that clients and what they're facing when they're in a situation where they don't have stable housing and they're dealing with concurrent disorders. So
thank you. And Aspasia, I have a compliment for you by Melva, a suggestion based on Duty Counsel Aspasia's presentation. It would be great to have presentations as this done to an entire treatment and programs group so that individuals understand the impact as presented and assist accordingly. Relationships do make significant differences. Great job in the presentation. Thank you.
Thank you.
Okay. And I think our time is up. Thank you very much, everyone, for having us. And feel free to reach out anytime to me as well if you have any questions. Obviously, I have limitations as to how I can assist, but that's what we're here for. So thank you.
Same here. I'm happy to speak to anyone about any of these issues, or I know we spoke about bail in general, but treatment courts as well.
Thank you. Bye, everyone. Have a good day. Enjoy the rest of the conference.
Hey, thanks. Thanks a lot. Bye.
Okay, it looks like when we will have to make some adjustments in terms of the interpretation. Nicholas, good to see you. So Dan and Keisha, I'll leave it up to you to introduce our next panel and move on. It looks like we're going to do consecutive interpretation instead of simultaneous, but you guys are pros. I'm sure you can handle it. So I'll leave it to you guys to take it from here.
Thank you, Justice.